Hi, this is Irina Shea, and this is part of our Wealth and Wisdom series. Today, we're going to talk about second marriages, estate planning mistakes to avoid. I love this topic. Over half of our clients are now blended families. It is the new normal, particularly with gray divorce of people in their 50s and 60s, still living another 40 years. They are repartnering and remarrying, and now there are stepchildren on both sides who maybe did not grow up together. And that makes estate planning very tricky. So I'm going to share my screen with some ideas for how to handle that. Okay. So the first thing I would suggest, if you haven't done this, is a prenuptial agreement um, or postnuptial agreement. So what is that about? It's about divorce, disability, and death. So you would do that with a family law attorney, not with us, but it's an extremely useful exercise because there would be full disclosure of assets of both husband and wife, and it would determine what would happen not only in the event of divorce, but in the event of death. So normally there is a what's called a one-third right of election in your spouse's estate. So even if it's a second marriage, if your spouse dies, you're entitled to one-third of their estate unless it is waived. So where does it get waived? It gets waived in a prenup, a postnup, or a waiver of right of election. Most people aren't even aware of this. So you're not necessarily saying you wouldn't leave your new spouse a third, but certainly depending on your asset base, it's an important conversation to have. So that has to be discussed and disclosed. The other big tricky part is IRAs. Most people's balance sheets are mostly IRA. We've just had tremendous market growth in the last 20 years. So it may be that one of the spouses has very large IRAs that they have been building already for 30 plus years before this particular marriage. So remember, with IRAs, beneficiary designations override any will or trust. Override. So if your IRA says to Mickey Mouse, that's where it's going. It's not going to spouse and kids. So a lot of times, this is where things get a little contentious. How much of that IRA should go to your spouse, right? Percentage to spouse, and how much should go to your children of your first marriage? That's very tricky. A lot of people have the philosophy, of course, it's going to the children. It was prior to the marriage, it's theirs. But the new spouse is saying, rightly so, well, hey, buddy, who's going to take care of you while you age? It's going to be me, and you cannot leave me high and dry. So this gets tricky. The other part that makes it even trickier is that spouses get lifetime stretch on required minimum distributions. Kids get tenure only. So there may be income tax reasons even to make the splits a certain way. What can you do about it? You got to talk to your spouse. You got to have what I call a kitchen table conversation. All right. Um, you may need coffee, you may need wine, depends how it goes. But either way, the kitchen table conversation has to be an honest assessment of what is fair. What is fair in a second marriage is up for debate. His view, her view, their view. Hash it out and be kind and be understanding. It also matters a lot about wealth disparity, right? So, wealth disparity, if one spouse is coming in with $6 million and the other's coming in with $1 million, that's going to change the answer of how things are handled. The $1 million spouse probably cannot age well on that alone. There probably has to be a slice from the $6 million side over to them, and then the balance can go straight to kids. So that is also important. Full disclosure. Don't hide assets. It's not going to work. You have to fully disclose what you have to your spouse. So in our meetings, we use whiteboards, which are like a blueprint um, on Excel, on an Excel spreadsheet. So what is that? It shows his, hers, ours, so we can put the pieces together. But before we can solve a puzzle, we need all the pieces on the table. It's extremely important so that we can solve, right? And when we do that, usually solutions sort of just tend to crystallize. It's very interesting, but when we're together, that usually happens. So, um, Another way to solve is to utilize a marital trust, which says the wealthier spouse, let's call it the $6 million spouse, can leave everything to the surviving spouse, but the remainder of that trust, of the marital trust, says income to spouse during life, but then it is remainder to children of first spouse, of first marriage, right? So let's pretend it's the husband for just a moment. If the husband leaves his second wife the $6 million in trust, she can utilize all the income from it, but at the end of the day is looping back to his kids. Okay. So that's traditionally been done when in a very traditional sense, it's been an older man with money and a younger second wife. Very much not the case anymore. All right. Often the woman has more money, or it's a reverse where the ages are flipped or similar or whatever. So, another way to do it is to consider slices. Okay, so if you don't want your kids waiting around another 20 years for your second spouse to die, because they're kind of like, we don't really know them. Are we really trusting that we're going to get anything from mom or dad's estate? That's kind of unpleasant dynamic, we'll call it, waiting for your surviving spouse to die. So another way to do it is slices. So you can take things like IRA or brokerage or whatnot and very carefully and thoughtfully leave, if you have three children, for example, a quarter share to spouse and then a quarter to child A and a quarter to child B and a quarter to child C and D, et cetera. Okay. So we'll say a quarter to each of three children, we'll say like that. So then they're not waiting around. So it depends on the dollar values, of course, right? It depends on the right of election. It depends on the kitchen table conversation, depends on all these things. But giving the kids something up front so they're not chomping at the bit waiting for your second spouse to die is often advisable. Okay. There's a lot more to this, and it is very unique to the emotional and financial dynamic of that particular blended family. So, if you'd like to learn more, feel free to go to our website at irinashea.com, click the Get Started tab, and our consultations are free of charge. So, with blended families, definitely take very much extra care in estate planning. Thanks.